tried that one yet.
My friend started Court Junkies, and she said it's really good. It's not by Ashley and Britt, but it's just another one that one of her friends recommended. And then I think I'm gonna try True Crime Research because they said
I have it on save.
they said Ashley and Britt said that was one of their favorites.
Yeah.
So I'm like, I'll try it.
Kirby like it.
Right, it's not you guys.
Kirby. Are those also not Kirby?
Yes.
It's so good.
Yeah.
I didn't listen to the
so good.
The Clockwork.
Yeah,
Yeah.
Clockwork or whatever it's called. I don't listen to that one. I listened to the Red Ball one. I didn't really like it.
It wasn't my
that much.
favorite, but
It
I.
just kind of felt like, I don't know.
Yeah.
I don't know what I thought. I didn't feel like them.
Yeah.
So it's like with the ones that have no conclusion.
I
Yeah.
know.
For a while, and then I like ran out all the murder ones, so now I have to listen to who are missing like book.
And they like, she actually likes the missing persons ones.
Mhm.
Yeah, and they
Says-
are interesting with the random ones.
Yeah.
Yeah, because you're like, why did we find them?
Yeah.
In this 32 minutes, why
Yeah.
did we find them together?
Yeah, I caved and got like the $5 the Patreon subscription, and I've listened to all of them now, and I'm like, crap. Now I have to wait
Now you can
every
cancel it
Monday.
and save your name.
I know, but I might save it.
And then get it back.
Yeah, and then get it back.
Yeah.
But
I did that for when I drove to Wisconsin. I'd like listen to all of them.
Uh-huh.
So I did like the Patreon and then I like unsubscribed
Yeah.
and I will resubscribe
Yeah.
and unsubscribe and catch myself up. Did I forget it?
the practice test was interesting. Did Madison talk?
What?
Did Madison talk about the practice test for family law?
She was talking about a practice test. I don't know if it was for
Okay,
family
we
law
had to do
or
one.
she had one for Hall she was complaining about.
The one for family law, she was asking us questions about like, how does the U.S. Supreme Court consider its role, or the judiciary's role in like, how to like, something with social change. I'm like,
I don't know how to ask them.
I don't know. This is not philosophy 101. This
Seems
is
like a question for the Supreme Court.
Yeah, right? Or it's like, how do they make a constitution? I'm like, I don't know.
Like, I'm not qualified.
It's like I could do like, if you asked me to explain like what the plan of the party is, or like multiple, what's this one? I can do that. Or if somebody still has the question, it's like,
I was lucky to have Faust for family law. He did not get philosophical at all.
I had her too. She's a wildcat.
No.
Seriously.
It is fun. Kind of.
It is fun. And you know what
She
it
put
is?
basketball games on the projector.
She'll tell you when you're gonna be on, and it's not really that big of a deal. And I've seen her since she came into my office.
I referred one of my cousins who had a friend with a dispute.
Oh, did
I
you?
think she's handling that. I don't know what
But,
doing the practical.
yeah, so she has some
I follow Julie Lane on Twitter. Every now and then I'll see Donna Faust's replies pop up, and it's always so funny.
Doing alright today? Yeah, how are you doing? Good.
Her final was unbelievable. The fact pattern, I'm sure was the same. It was like so convoluted. It was like 400 bachelor stories, like you would see on a reality show.
Still wasn't mad that I went to see it.
Hmm?
At least I wasn't mad that I went to see it.
No, it was kind
I'm
of.
really glad I didn't realize this. I only watched like one or two episodes, but I also didn't
Yeah,
realize.
I just knew the names and then the other kind of names. It's all based on that. I had to take it after shows. After
Yeah,
I had to take it
I didn't take that.
I didn't even
Shut
take
it,
it.
it's,
I didn't take it like,
Just like watch it so long.
I know that's what I did. Well,
I feel
all
like
of his
that'd be
questions were based on TV shows.
I mean,
Like all the characters were.
But I never got a notice to do that. That's why I'm hesitant.
I had like the last time I had one way down the table underlying this one person and that stupid fact pattern.
And then he only asked to address like 4 people.
Yeah.
It's like, well, that.
My plan is like everyone, so I was, so you're gonna hear about everyone.
Yep.
I couldn't like strategize, I like change my strategy throughout, cause like campaign, just like not knowing what happens to me, and I'm like, why do I have like test anxiety all of a sudden? Like, I don't
I
have
missed that
time.
one up big time. I spent like 20 an hour on the multiple choice.
Same, I
I
do.
only wrote good for you.
Me too, and I'm like, what have I done to myself?
I know. One of the multiple choice, it was number 2, I still remember. I kept
Oh, what
looking at it and looking it up and I'd go back and
Me
change
too.
it. And
I
I
was
would
like-
go to the next one and I'd go back and change it. I'm like, what are you doing?
I know.
I got on the run.
You're going down a rabbit hole, and it's like, you can't get out, like, as long as you answer one question, like, you're gonna hit yourself in the face.
I gave myself like 2 hours to do the essay, and I still ran out of time. But I also was stupid and started looking past the tuition.
I
I
know.
walked out there feeling I've never
I know, I thought I like that for that was horrible.
I wasn't expecting it.
Because he didn't tell us, told us not to. Yeah.
He was like, it's pretty chill.
I
Like, I'm like,
If
this
it
is
would
not
have just
chill.
been the essay, that would have been fair, right?
Yeah.
If we would have had 3 hours on the essay,
Yeah, that
I
would've
could have
been
dealt
fine.
with that.
Yeah.
But for it to be a 20 multiple choice at the end.
And for him to say, I don't want IRAC, I want an outline, I want it short.
Well, then I wouldn't write in my outline. I'm like, hopefully this isn't too long because he can't like really count off. Like he counts off.
Like, so I don't know how to build an essay.
Do what?
Like, none of us know how to build
I
an
know.
essay, because I feel like you can't for that, or you do it, you know, your pancake. and
Right,
like,
when you're running out
keep it
of time.
flexible.
Especially when you have professors like Avery, who says, yeah, go summarize bullet points.
Like, once I've done that, is when I'm already.
Are you gonna be
No, because we've got to do Barbary, and so I feel like that's just gonna flush out the end. So I don't know what I don't need to get.
Right.
So I mean,
I just had strategies. I thought that told me to
I
send this much time.
kind of do like seeing like a bad exam and a good exam. But I don't like grading 9.
I like the way she was
It is
like,
less greasy.
on the 30 minutes. 1 minute
I'm good. I'm watching my sister's house and dog. Fine, I don't mind it at all. The only issue is he's epileptic and requires strict regular examination at a very certain time. That time happens to be pretty much any time between 6:30 and 7. David ran outside to go to the bathroom in the top of my car. Done getting through the whole way to make it. But I made it, so we're here. It's all right. I did use it. I also used it for tax hours. But turn in your
I thought about it. I thought about emailing him. I was like,
And then meanwhile, just.
or sending a text.
Oh, I wish you would.
I won some things on emails, but no, this one I remember. I remember it like Friday night being like, oh, dang it, I do have to have it done Saturday at 5 or even like Monday. We got it, it's alright.
Outside of the last 2 years, I was like, I am so glad that Ross changed his deadline.
Oh, yeah.
Friday
The Tuesday,
to, well,
Mondays, whatever day it is.
we can. It was like the first week of summer. What takes schedule.
Yeah.
I understand why. I mean, I have kids down the weekend because they were at
Yeah.
turn really early.
I had it done early rather, which didn't happen to a pure chance, but I had it done before Friday of last week. Complete happenstance that it worked out, and I just had like a really easy break that I could take advantage of.
She said some people are gonna get.
But
I know.
Yeah, sounds fairly.
it was.
The week before was.
Oh, that was
unbelievable.
long.
All right, guys, let's get started. So
Dude.
we're at 7 o'clock. Will somebody pass me the sheet? we all start with? So welcome back. This is our third class. Of course, we did not have class last week due to the MLK holiday. Just a quick update kind of on where we are. I keep updating the Twin page. So if you go on Twin, you can find under legal drafting, the syllabus is kind of continuously updated. It's the end of the syllabus. I think it's like you can download it and just author and just look at it and the preview option. But the first 3 pages don't change. But then you'll see I've updated the schedule a little bit. I was kind of thinking about what I wanted to do this week, and I thought it made sense actually to not do a drafting exercise for this Saturday. This will actually be probably the last one. You know, we're early on, so I think it's okay that we're not quite ready to start some of the substantive exercises. We're not going to do one for this coming Saturday, but thereafter it'll be pretty steady stream almost every week. So this. I was thinking about it on the way here. I was thinking, oh, it's kind of like the calm before the storm, and I thought, well, the storm is not a storm. It's just kind of a constant routine. So it's not like anything scary is coming after this week. Just kind of substantive assignments. But anyway, so this is the third class. What we're going to do is review the drafting exercise that you did do for this class. We'll talk about that in some detail, and then we're going to talk about the reading assignment for today. Which of course is this general introduction to really civil litigation related documents. So we're going to spend some time really kind of introducing you to the different documents that you'll see during the course of civil litigation. And that will really kind of get us into our reading assignment for next class, which is the first pleading that you see in civil cases, and that of course is a complaint. So we're going to not have a drafting exercise for Saturday, instead just kind of a short, relatively short reading assignment. But I think that's somewhat detailed with respect to the different components of a complaint. And then for next class, we'll spend the bulk of, since there won't be a drafting exercise to review, we'll spend the bulk of the class actually talking about complaints. What's the purpose of a complaint? How do you draft a legally sufficient complaint? What are some procedural matters that are at play with respect to complaints? And really focusing kind of more heavily on the fundamentals of drafting a complaint. What does a complaint look like? How do you draft one? After that, the kind of looking ahead, you will not have to draft, I don't anticipate, unless I change this, but I don't anticipate changing it. You will not have to, at that point, draft a complaint, but your exercise will be to review a case file, and then you will complete the exercise or an exercise on assessing a cause of action and critiquing a complaint to get you in the mindset of drafting complaints before moving on the following week to actually drafting a complaint. And then we'll start kind of more systematically drafting documents related to civil litigation. So you'll have to draft a complaint, and then you'll have to draft an answer, and then you'll have to draft a motion to dismiss. And then we'll move on to some of the other documents towards the end of class. So this is kind of the last, not that any of it will not be calm, but this will be the last kind of relatively quiet week since this is a drafting exercise. Any questions about where we are, where we've been, where we are, where we're going? Today what we're going to do, hopefully it'll be a little bit of a relaxed class in the sense that we're going to talk about these 2 cases, kind of interested to get your all's thoughts on how they're drafted, and what lessons we can glean from them going forward. And then we'll also introduce the idea of just civil litigation related documents generally. Any questions about that? What we're doing? How's your all's semester going so far? Like this is the time where it turns from like fun to like maybe I should actually start doing something substantive. And my favorite time of the semester is always the beginning. My least favorite is like I would say 3/4 of the way through, because you'll end up, I haven't outlined anything. It's a nightmare. So, okay, hopefully that will not be you this semester. All right, so let's talk, before we actually get into this discussion about civil litigation related documents, the general introduction, I did want to spend some time talking about these drafting exercises, the Nettles-Nickerson case and the Belogan case. One kind of procedural thing, and I forgot to mention this, but you can do it for next time. It's always helpful, it was helpful at least last semester, if when you come to class, you've obviously already submitted them to me. I have kind of hard folders for each of you with your name, with your last name on it. And what I like to do is put a hard copy of your drafting exercise in there as well. So I should have told you this and I didn't, but for next class, will you bring a hard copy of the drafting exercise you completed? And then I can collect those and then put them in each of your folders. But if you don't have a hard copy in front of you, you almost certainly have one on your computer. What did you think about these cases? Let's just go in order. Looking at the Nettles-Nickerson case, and there's no right answer, but the first question I asked you was, as a general matter, is the opinion well written? Does it satisfy the needs of the audience? Why or why not? Does anybody want to volunteer? Yeah.
I thought it was fun. I mean, personally, I thought it was cool because I knew like the area and stuff.
Oh, did you really? Okay.
East Lansing, Ocean Mist, all that.
Okay. Well, there you go. Were you ever at the tap room
No.
in neighbor? When was the last time you were at Okemos, Michigan?
Yeah. No, in 2009, I definitely wasn't able to get into the.
Well, not legally. That's the end of that conversation. Okay, anybody else? Well, what do you think, though? Okay, so you thought the facts you could, maybe not relate to, but you found interesting.
And I thought they were clear.
Okay.
I was pretty clear. I mean,
why were they clear?
it didn't use too much unnecessary information, I guess.
Okay.
So they were kind of concise.
Yeah.
And then, it wasn't really long. I thought the paragraphing was pretty good. And
Okay.
stuff. They kind of had topics.
Okay. Yeah, no, I think that's fair. Any other reaction to that? Yeah.
So
Tell me your all's names again, too.
I'm Kaylee.
Kaylee. Dimitri, okay.
I liked this fact pattern too because I thought it was easy to read and I thought it was it kept my attention, and I really liked that they used the witness, Mr. Williams. They used his testimony to kind of walk you through, and I thought it gave a really good. It put me in the shoes of I would be nervous if she got into her car too, instead of just these police officers who came off the street. It made me sympathize with him, and then I guess with the police officers a little more than if it was why did they just go knock on her car door type deal. So I
Yeah.
like that.
Which is consistent with the result of the case,
Mhm.
right? I mean, ultimately, the court determined that the officers had qualified immunity. Any other reactions? Anybody think, there could have been something done differently? At least we're kind of limiting ourselves right now, I guess, to the facts. Any other reactions?
I just kind of thought it was kind of organizationally off for me.
Okay.
It was facts in the beginning and then some analysis and then let's go back and talk about the facts again,
Yeah.
but add some detail to it this time. And so, I don't know, I feel kind of funny because everybody else says that it's okay. And I was kind of I don't know about this. I wasn't as engaged by it.
Yeah, what do you think could have fixed that? Because I think you're right about that. There's an introduction and then you go to the facts and then you kind of go back to the law. Do you think anything could have, in a short way, if you were editing this, short of significant overhaul,
Yeah.
what could you, which maybe it requires, what could you have, or might you have suggested to make it more clear? Because I actually agree with what you're saying. I think it is kind of jarring. You feel like you're kind of in legal analysis and then out of it, then you're back in it. Is there anything you think could have maybe fixed that?
The only thing I could think that you could do would be to have somebody read it for you. Before it was
Yeah.
issued, like a clerk who would maybe give some feedback. I don't know.
Yeah.
I can't give any specific cut this. I think they shouldn't have gone back to the facts later. It's they just needed to stick with where it was.
Yeah.
And sure, I understand they need to analyze it, but it just, I don't know,
Yeah. One thing I was thinking that's related to that is headings, but does anybody else have a reaction to that? Yeah.
That's what I was gonna say, is I thought it was well written, but it didn't go from good to elegant or great, and I thought what was lacking was that it wasn't aesthetically pleasing, and certainly sections or headings or titles or something where along the lines to just guide you.
I think so too. I actually went back and when I was reading it, I actually put Roman numerals in certain parts because I was this would, I think, be improved if it was clear to the reader kind of where we are because I actually, and maybe I'll let this up at the end, and if I don't, maybe remind me. I actually think that each of the sections serve a kind of a specific function, but I don't think it's clear to the reader because there's no headings. Yeah, somebody else had a hand.
Oh, me. I think everyone's being so. Leanne, I'm gonna be that bad guy.
No.
I did not like it.
Okay, no, that's fine. Nobody has to. Oh, I'm offended.
Yeah,
You didn't
well,
like a Sixth Circuit.
Well, it's because I agree.
I didn't think it was that great.
The minority here,
Yeah.
because
Yeah.
everyone. Yeah, I thought they needed a roadmap. like, tell me what you're gonna tell me, and
Yeah.
then go ahead and say
Yeah.
it. But it was just too long with the facts. I'm like, okay, this is dragging on. I get it, this is important, but like, and I get how they tied it back to the facts of the analysis, but
Yeah.
it just did not flow well.
Yeah.
And if I'm like a young attorney, which I hopefully will be a young
You will.
attorney, I'm like, yeah, no, I need to read this again. I'm like, I already got lost in the facts because it's just so
Yeah.
long. It was very long with it.
Yeah, no, I think that's right. I mean, I think that's kind of since we're kind of focusing on this, I'll kind of mention what I wanted to mention more substantively, which is, if you look on page 289, I guess it is, it's the beginning of the substantive opinion. Of course, there's these key sites and tools you can use if you're doing legal research. But the opinion starts, and we will come back to this when we study judicial opinions in more detail, but I think it's kind of worth noting that across documents, less so in complaints and answers, and maybe even motions to dismiss, more in the informing and persuading category of legal documents that we'll think of, memos, emails, and certainly judicial opinions, this first paragraph, honestly, I think is there to function as an introduction and a roadmap. And it's supposed to be just kind of a quick and dirty, this is what is happening in the entire case. And so they basically just say, Judge Rogers basically just says, look, here's this person who was arrested for this reason, but her case gets dismissed. Nevertheless, she ends up suing the officers and basically makes two arguments. But those officers are entitled to qualified immunity, right? The district court held that the officers had qualified immunity. She now appeals, but for this reason, she wins, right? Since there was a reasonable basis to believe that Nettles Nickerson was operating her Hummer while intoxicated and was therefore violating Michigan law, the district court properly determined that the officers had qualified immunity. So it's a skill, and we can certainly differ about whether the judge achieved it here, but you want to kind of it's certainly in a judicial opinion. I also think in a memo, in an email, and kind of just correspondence generally, substantive legal correspondence generally, you want kind of a short intro that tells you, why are we here? If you're on appeal, what was resolved below, and what the answer is now, and why that's the answer. So that obviously there's a lot of tools now that you can glean from maybe the key sites or the head notes or some other kind of non-judicial correspondence, whatever West puts in there. But if you're reading a case, the goal of that first paragraph, I think, is to give the reader an overview of what's going on in the entire case, so that if you don't want to learn about qualified immunity, or your case isn't about qualified immunity or Michigan DUI law or whatever it is, then you can kind of read that and say, I don't need this case. Or you can read it and kind of think, I need to keep going, right? So I don't think necessarily the opinion would be approved to have any headings there before that intro. It's the first intro paragraph. It's just a couple of sentences that kind of functions a little bit as a thesis or an introduction to your entire piece of writing. I think what would have been better is if right after that there was a Roman numeral 1, and you might have included the word facts, right? Because then right after that, you're saying, okay, she was arrested for sitting in her car. I do love that it's a Hummer. I mean, Michigan, which I had spent time in college, never driving a Hummer, by the way. 1999 Toyota Camry. But you just kind of, and the facts are kind of hilarious. She's in this Hummer, she stumbles to this Hummer, and turns it on, and we can talk about the facts in more detail, but it's just kind of hilarious. But here they're just saying, look, she's sitting in her car, she's charged with a DUI, they throw it out, she nevertheless sues, the district court throws that out, and we affirm because of these two reasons. I think the judge achieved that much. Where it goes sideways is then you feel jarred because you're thrown into facts. You're like, okay, law, some facts, what's going on at the beginning? If it's clear to the reader, hey, this is just like the 30,000-foot view of the case, right? then I think you're like, oh, I don't have any expectations about whether I'm supposed to learn about this factually. I don't have any expectations about whether I'm supposed to learn anything legally. I'm really just supposed to be oriented to what this is about. Has anybody, maybe you wrote a thesis paper in college, or you wrote a seminar paper in law school, your first year writing class. Has anybody ever said to you, like, hey, just give me the 30,000 foot view, give me the 30-second elevator pitch. Like, what's your argument? I joked about it last class. Like, here's my 3 reasons why I want to go to, you know, whatever, Quills or watch Homeland or whatever it is. Like, just give it to me quickly. That's this, right? And I think it's a judicial opinion here, but I think the same could be true in just writing generally. Like, up front, you're emailing the dean because you want to, you know, get the reserved room LL75, which I wouldn't reserve, but maybe you want to. And you say up front, like, hey, I'm emailing you because I want to reserve room LL75 for a student organization. And then you might go back and say, oh, well, you know, we started this running club and whatever it is. Then you'll go back. But this is the 30,000 foot view. I think the judge achieves it. But what's jarring is you don't know that you're then going to the substantive facts. So if you had a heading here, I think then you'd be like, oh, facts, okay. And you start on the evening of May 8th, 2009. And what's interesting about the facts section here is, I think a couple things are going on. One is the judge is trying to, in just a very narrative way, tell a story about what allegedly happened in this case, factually, like real facts, not like procedural facts, which are like the not fun facts. We want the facts, what happened? And I think the judge tells it in a mildly interesting way, right? I mean, the thing you've got to ask yourself about a fact section here is, it's kind of like that Posner test or the Paulsgraph test, which is like, can you read it one time and walk away and have kind of an understanding of what was going on in the case? I think you can, right? I mean, I think it does succeed in that. And in somewhat of a humorous way, I think. Maybe not humorous isn't the right word. I mean, it wasn't humorous for her. But I think for the kind of average reader, I think it's kind of like, you can picture what's going on here. She stumbles to her car, sits in there, turns it on, brake lights go on. I mean, it's also told in a way, why did the judge tell it this way, do you think? I mean, what's your reaction? I mean, you know, maybe does anybody?
He wants to get like a visual.
Yeah, he wants to give a visual. I mean, let's just do what you're not supposed to do in law school, like me and the instructor. Like, what do you think? Like, can I share what I think? Is that over the line? I think maybe she was operating it. Is that like rogue? I mean, I say like, I'm not like ripping off, you know, political parties here. I mean, I just kind of think she was in the car, you know? Now, good people can disagree about whether she was operating. Like, is it really operating? But like, the judge, well, okay, I clerked for the judge. So like, I think the judge thought she was operating it. Or the judge thought that she was operating it enough that it was a question under the law whether what she was doing was operating. And the minute you're in that world, that's qualified immunity, right? Do you see that? Like, if good people, who thinks she was operating? It's all a safe space. If you don't think operating, who thinks not operating? Okay. I think the answer is qualified immunity, right? Then that's kind of what it means. That's what qualified immunity means. But what do you all think? Why do you think the judge said it this way? Yeah.
Well, I just thought the facts in particular were important because within the context of qualified immunity, the officers had to have a reasonable opinion, and all of those facts go into forming that reasonable opinion.
Yeah, exactly. The facts are written, the judge, I think, tries to write them in. These are also judges, so like, tell me a story. Okay, well, this is something like Harry Potter, right? It's not that gripping. You're not like, oh my God, who's in the Goblet of Fire? That's the one we're on now. It's an amazing movie. I thought I liked the third book. I liked the fourth one. Yeah, it's not that good. I mean, it's a judge, right? And he's kind of like dry. He's a wonderful person, but you know. But I think he knows the result and is like, I'm going to write these facts clear, hopefully, engaging, hopefully, but written in a way that also kind of leads you to the result so that by the time you get to the end, you're thinking, you're suing? You're kind of lucky that you didn't get a DUI, right? I mean, that's what I thought. I'm like, give me a break. I'm thinking, really? Lawsuit? Like, you were this close to being in the drunk tank. Or maybe she was. I guess she was in the tank, right? I mean, she did get acquitted, yeah.
I just thought that in Michigan, the standard for proving a DUI is so like high. I mean,
Yes.
right?
Makes you want to, well, no,
In
that's
Florida. Yeah, practicing like DUI defense in Michigan seems pretty easy.
Yeah, we should open up a shop. You can make good money, yeah. Well, I went to college. This is like, worlds are colliding now. I'm thinking back to my days, which were like last week. Yeah, I mean, it seems unreasonably high, right? But which way does that cut? I mean, how does that?
Well, I just, like, kind of what you said, I felt like it's ridiculous that she's bringing this, like,
Yes.
civil suit against the police officers.
Yeah.
Yeah.
Now, here's the thing. Feel free to disagree with that view. There's nothing wrong with it. That's my view. I don't know if I should be sharing that, right? Is that like easy to do in law, whatever? That's my view. If you disagree with that, that's totally fine. The lesson here is if you disagreed with that and thought what was going on was unreasonable and you were on this 3-judge panel, you were writing a dissenting opinion, your facts might read differently, right? Your facts might not focus as much. I mean, you would not want to be inaccurate in your description of the facts, but your facts wouldn't emphasize all of the operating she was doing, right? In plain language operating. Obviously the court, right? I mean, the court thought this isn't operating under the law, right? You might emphasize she didn't move it out of park. Never once did she put the car into drive. Never once was her foot on the gas pedal, right? She never left that parking space once. The car never moved 1 inch during the course of her entire time sitting in the car. She responsibly chose not to depart the parking lot, right? I mean, all of that is also presumably true. And those maybe are the arguments that were made during the state court proceedings, the criminal court, right, that ultimately led for her case to be either thrown out or dismissed or whatever the case may be. But so the point is a couple things. One is I think you want to write the facts as clearly as possible. We talked about that. We did that with the reading last class. Talked about that with the reading last class. Active voice versus passive voice. Does it pass this test? You can read it once. It's clear. Another thing that occurred to me just in thinking about it, there's not a lot of cites. Now what does that mean? Like, don't cite to the record? I think you've got to follow whatever the standard is in the court. You know, we read some about that. We'll continue to read about local rules and abiding by that. But there's something nice. I think judges have a little more leeway with this than maybe litigants do. But there's something nice about reading a piece of legal writing that's not cluttered with CR1 at 2, 4, -6, period. Then she went to Okemos, Michigan. CR2 at C also. Because I want to read a story. You know, so figure out, can you kind of tighten it up a little bit? Are there places where you can maybe cite at the end of the paragraph? You know, okay, these facts come from this portion of the record, as opposed to after every sentence. I'm one, and maybe this is just me, but I've always kind of been cognizant of how does it look on the page too. I think that matters, right? I think good legal writing does include kind of tightening up your citations and making sure that it just doesn't look like a mess on the page. And I think the judge hopefully achieves some of that. You go through the facts though. You get down here, right? She's running, but she's in her running but still parked car. She's in the driver's seat. The judge comes up there. It is amazing. Blood alcohol content, 0.165. I mean, somebody had a few cocktails. They must serve some pretty, strong, martinis or whatever she was drinking. But anyway, well over the legal limit, they arrest her. So then we move on page 290, column 1 over to column 2. The facts, notice though, the story kind of ends and the facts turn procedural. So you go from like fact to procedural facts, right? It says the state trial court, however, dismissed the charge, finding that Nettles Nickerson was not, quote, operating her Hummer as that term is defined under Michigan law. The Michigan Department of State made a similar finding in Nettles Nickerson's license restoration proceedings. Accordingly, Nettles Nickerson's criminal case was closed and the license was not suspended. Interestingly, I think the judge does a pretty good job here of not getting into all of the proceedings below, right? I mean, the whole issue was she wasn't operating it in their view, right, in the view of the court, and that was it. You could have gotten into a lot of discussion there about whether what was operating, why was it not operating under law. I think that really would have made it go even further wayside, because you would have been lost in why are we even focused on what was going on in some ancillary proceeding? Shouldn't we be focused on what happened in this case? And I think the judge pretty quickly moves beyond that section of, so we've got, I'll call it facts, right? Like the actual facts. Then these are kind of procedural facts in the other case. This is short, right? And then over here, you get to procedural facts here. The argument maybe could be made that there should be subheadings here, like A, B, C. Maybe you want that. Maybe you think that's going to aid in the view of the reader, right? Procedural facts. In the other case, procedural facts here. This is an interesting choice of words. Unsatisfied. Note the transition. Unsatisfied. Like, what does that mean? What does that word mean? And that's there for a reason. What does that mean? Yeah.
Like, she didn't just, like, take the money and run here?
Well, not money, right? I mean, she was...
Well, kind of like figure of speech.
Yeah. I mean, she could have just been happy with the fact that she blew a .165 and has no criminal record and has her license. I mean, that's kind of a bad... On the other hand, though, right, I can reasonably be like, you know what, bullshit, you person who just made that argument. Like, she wasn't operating her Hummer. So don't act, you can blow a point. We can all have drinks right now for the next 2 hours. I mean, we can't. Class, it'll be like an open bar here. Everybody gets an A! Woo! Everybody's taking legal drafting. It's mortified. I'm not carried off campus. But we had a great time. .165. Like, I mean, we can all go out for drinks later, blow .165s, and then, like, walk home safely and do, I mean, I'm not saying it's a good thing, right? But, like, that wouldn't be a violation of the law. That would be a night out in Louisville, right? So, you know, you can make an argument that what the result isn't totally right here, but the point is the judge had the result he had in mind, and he wrote an opinion that reflected that pretty clearly.
When
Yeah.
I see unsatisfied, it looks to me like he says she's pissed. I'm going to do something about this because it didn't go the way that I thought it should have done.
That's interesting. But I think that could certainly be read that way. Do you think that the judge also thought that it was justified, her being pissed was justified?
I don't think so. I don't think he would have chosen that language.
No.
But I think that he was just trying to interpret what her attitude about it was.
Yeah. That's interesting. I know. I wonder about that. Like, I think you could look at it two ways. One is, was he kind of channeling her like she was unsatisfied? I mean, obviously that is what it means. Like, who was unsatisfied? Well, she was not satisfied. But it is loaded. It is like erroneously unsatisfied is what it suggests, right? I mean, spoiler alert is like, I kind of know. I mean, I clerked for the judge during this time. So, I mean, I don't know. I'm not like, it's been 8 years, right? I can't even remember where, like, I put my keys. So I'm not saying I exactly remember, but I think that my sense of it is, and I'm not speaking for the judge. It's important for me to say that. But my sense of that word being there is the court thought that the lack of satisfaction on the part of the litigant here was not justified. Doesn't mean it's right. It means that words matter. And I think the facts are written here, and then down here in a way that reflects the legal analysis that is to come. And I think you ought to think about that. Like, have you ever read something, you probably read emails or memos from colleagues, or, you know, even judicial opinions, where you think the facts are leading you in one direction, and it's kind of like jarring. That's not a good thing, right? Like, clarity is our big thing in this class. Like, I think if you come away from this class with nothing else, other than there are 3 reasons to watch Homeland, right? If you come away with nothing else, come away with clarity. And that's what we all want, isn't it, in the law, right? Like, don't you want to like leave class thinking, gosh, I really learned something about torts today, or contracts, or I'm not lost in secure transactions, or whatever. I'm like, I understand. It's that whole thing we talked about last class, which is like, somebody gives a presentation, do you come away with it knowing something, or do you come away with it confused? Here, the goal should be clarity, and the takeaway with the facts is, you want your facts written in a way that's accurate, right? I mean, it reflects the record, but also comports with the legal analysis that is to come. And so the judge kind of is signaling that, I think, in that word unsatisfied. But he says unsatisfied. Nettles-Nickerson sued officers Free, McCready, and Harris in federal court. Nettles-Nickerson argued, among other things, that the officers unconstitutionally detained her without reasonable suspicion and arrested her without probable cause. The district court, however, granted the officers' motion for summary judgment, holding that they were entitled to qualified immunity because Nettles-Nickerson did not have a clearly established constitutional right to be free from detention and eventual arrest. It gets a little bit confusing here because you're starting to think about legal concepts, but also he gives some of the other reasons, and he says Nettles-Nickerson was operating her vehicle. The case law was sufficiently unclear to allow a reasonable officer to believe that Nettles-Nickerson was operating her vehicle. Nettles-Nickerson now appeals that ruling. The key here, though, is what you want. What you want is the facts here, the procedural facts. A lot of times there won't be an ancillary case. You want to move quickly from facts to procedural facts, and you want to kind of end your discussion here of a background fact section with kind of being on the tip of your tongue on what's the answer in this case, right? So whether it's an email, a memo, a judicial opinion, you want to kind of state up front, like, hey, this is the 30,000 view, this is the full answer. Here's like a big picture view of where we are and what the quick answer is. And then you step back from that, block that off in your mind and say, okay, now I'm going to talk about the facts, right? And you give the facts, both factually and procedurally. And at the end of the facts section, you want to start a second substantive section, which is really the analysis. Some people call it the discussion, but it's really the analysis. Notice it's not the law. There's no law section, right? It's an analysis, and I think it would have been better if the opinion had that, because I think it would have been much more clear to the reader, hey, we're now blocking this off. We're moving on to an analysis section. You want to leave the reader on the cliff here, and you want the answer right here. The answer, right? Not under the law. Here's my dissertation on qualified immunity, right? I mean, this is where, think about a law school exam. This would be what the professor gives you. There might be a question at the end, and then you would start your answer not with this, but with maybe some view of this. You would have an issue statement, and then you would have a bunch of rules, right? And then you would analyze those rules and come to a conclusion. You should probably keep doing that in law school on your exams. In writing, you have this 30,000-foot view. You have the fact section, facts, and procedural facts, leaving the reader on the tip of their tongue, or you're on the tip of your tongue. You go to the analysis and you immediately give the answer. And what's the answer in this case? Notice the head notes pick it up. Wes is pretty good at this. They know where it starts, right? Officers Free, McCready, and Harris are entitled to qualified immunity. I mean, that's the answer. Now the question is, why is it the answer? Now, to be honest, I don't think it's the best writing here. I almost would have put the period there, right? There's your answer. Then you've got to do what I call prove it, right? It's like a proof. It's like bottom line up front, proof-like writing. You give me your answer, Kansas City's going to win the Super Bowl, period. Why? Well, let me tell you about the NFL. No! Why is Kansas City going to win the Super Bowl? That's because Patrick Mahomes is better than Jimmy Garoppolo. And because Andy Reid, well, that's a reason why they shouldn't win. Whatever. Andy Reid is overdue. It's a bad reason. That means nothing in sports, right? but those are your reasons, right? That's what you would state up front. Kansas City is going to beat San Francisco in the Super Bowl, period. That is because, or you could say Kansas City is going to beat San Francisco in the Super Bowl because Patrick Mahomes is better than Jimmy Garoppolo, and Andy Reid is overdue for a Super Bowl victory. What's your first substantive paragraph going to be after that, right? That's your that's your answer. That's your bottom line up front answer. What's your next substantive paragraph going to be? Patrick Mahomes is better than Jimmy Garoppolo, period. Right? It's your reason is, if you've got bottom line up front, which is basically answer with reasons, 1, 2, the first paragraph here is going to be reason 1, and then why. Patrick Mahomes, does anybody know, well, some of you know, I mean, if you follow it. Right, Patrick Mahomes is better than Jimmy Garoppolo, period. Why? Well, that's because he is. So open your eyes. I mean, Jimmy Garoppolo doesn't throw the ball. It makes me insane. Oh. I'm a Bills fan, so I'm really bitter that they didn't draft Patrick Mahomes when they had the chance. Instead, they went for somebody who's worse. I'll never get over it. Why would, if you see a good player, okay, I'm going to go. He's amazing. Just pick them at picking. They had Lamar Jackson. They didn't pick him either. Stupid. Oh, they're all better. Okay. You give the reason Patrick Mahomes is better than Jimmy Garoppolo, period. Why? That is because he has more, he averages more, he has a higher completion percentage. I'm making this up. This may be true, may not be. He has a higher completion percentage. He has more rushing yards, which in today's NFL, by the way, matters. And he, has fewer turnovers, right? And then you go through each of those sub-reasons. But it's always clear to the reader where this whole thing is going, right? The facts are written in a way that's like leading the reader to believe that Kansas City is going to win the Super Bowl. You say that they're going to win the Super Bowl, right? You give why, 2 reasons. Then you prove each of the reasons, like a proof. The judge does that here, right? Look at this. What's the answer? This is in the bottom of page 290, over on the right-hand side. It should have Roman numeral 2, I think, analysis, because then this little jarring thing, I think that you're right. Without it, you're like, where the hell am I? I was kind of in it. I felt facts. Now I'm kind of back in it. Wouldn't it have helped if it was like clear to the reader, these are the facts. If you don't want to talk about facts, if you don't want to read about Okemos, Michigan, I'm sure it's a lovely place. Many of you don't want to read about Michigan, right? Then you don't have to. If you're just trying to get in and get out of this case for qualified immunity law and cites, you want to know that I don't need to read this, right? You want this. Okay, so they give the answer. Officers Free, McCready, and Harris are entitled to qualified immunity. Why? I don't think this is super clear, because it would not have been clear to a reasonable police officer that detaining and arresting Nettles Nickerson was unlawful. And you're thinking, well, what relevance is that? And then I think the judge tries to explain it. Look, and then judge kind of is guilty about falling in a little of the, like, I got to teach you about qualified immunity for a minute. Like, here's a little law. What's the law? Qualified immunity is warranted even if a constitutional violation has occurred if the right violated was not clearly established, and this court may proceed directly to that inquiry in appropriate cases. What you really have to stop and realize is the judge is teaching you that in order to have qualified immunity, the real analysis is you need 2 things. You need to have a constitutional violation, and you have to have the right violated being not clearly established. I may have messed that up. But the question is, was there a constitutional violation? And was the right violated clearly established? This is where, honestly, I hope this is making sense. I have so many thoughts here. This is where, honestly, the way you have strong legal writing is just not write for a minute. Like, be willing to not write on your computer and get out one of these and think for a minute. Because if you spend 5 minutes in thought about what you want to say, then this becomes so much easier, right? But has anybody written something where you thought, I should have just outlined it first, or I should have stepped back? The minute you think, like, I'm going to send somebody an email, don't. Stop and think about what you want to say. And I think, to be honest, who am I? Again, this is all just my opinion. But my opinion is there could have been a little bit more stopping and thinking about what we're trying to convey, and then conveyed it in a little more of a clear thought. The question here is, was there a constitutional violation, and was the right violated clearly established? If you have a constitutional violation and the right violated was clearly established, then there's no qualified immunity for the officer, right? If an officer violates one of your constitutional rights and your rights were clearly established there, that officer doesn't have a qualified immunity defense. Now the question really is, okay, well that makes sense, but what does this mean? This is often easy to determine, right? Like, were you arrested without a warrant and without probable cause, right? Then you figuring out whether your constitutional rights were violated, I mean, that's a whole body of law too, but that's often easier for a court to determine. The question is, was your right that was violated clearly established? Well, he goes on and says, Judge Rogers that is, says, the relevant dispositive inquiry in determining whether a right is clearly established is whether it would be clear to a reasonable officer that his or her conduct was unlawful in the situation that he or she confronted. Basically meaning, look, we've got to ask ourselves, was there a constitutional violation, and was the right violated clearly established? Meaning, would a reasonable officer know that his or her conduct was unlawful? If the officer would know that their conduct was unlawful, then they're not going to have qualified immunity defense. But if the officer might have thought, okay, I understand I ran afoul of your constitutional rights, but it was a gray area, hence the who thinks this, who thinks that. If it's a gray area, then that's where we're going to protect officers. And this isn't a class on qualified immunity, but you got to get that, right? Like, officers, it's a tough job. You've got to make tough decisions, right? And was she driving? I don't know. We got to make a judgment call here. And I think, in theory, it's, take it for what it is. You can disagree. But the theory behind it is when you get a situation like this that's kind of gray, they may or may not commit constitutional violations. But we're going to protect officers from civil liability because of this idea, which is like in gray areas, we're going to say qualified immunity. What we're not going to say qualified immunity is, oh, let me profile you because you're a certain race or a certain religion or you're a woman. Oh, I'm just going to arrest you. I don't need probable cause. I don't like women. Arrested and beaten for no reason. No! Sue their ass off. Go for it and I'll represent you, right? But do you see what I'm saying? So that's the theory behind it. The problem is, I don't think that comes across clearly here, right? In part also, because what the judge kind of quickly does is skirts over this and says, look, really? Even if you have a constitutional violation, you also have to look at this, and we're going to proceed to this inquiry, right? We're immediately going to proceed to this inquiry. So what he makes the whole case about is this. So how could you kind of clean that up a little bit? Well, I don't know. I mean, I'm not in the position of like editing this case. But if you were, you might have started out by saying something like, go back to the beginning of the analysis and say, officers Free, McCready, and Harris are entitled to qualified immunity. That is because while there may have been a constitutional violation in this case, the right violated was not clearly established. That is because the relevant inquiry is whether a reasonable officer in this situation would know that his, in this case, conduct was unlawful. And here, given the facts, a reasonable officer would not have known that the conduct was unlawful, right? Or good people could disagree about that. And then I think we kind of get there, right? Because ultimately what you're trying to prove really is a fact-based determination, right? The question is, like, would a reasonable officer know? Would you know, hey, that was an unlawful arrest? And really, it's necessarily a fact-based inquiry, right? The judge goes and says, even if we assume that the police lacked probable cause, even if we assume that there was a constitutional violation in this case, officers Free, McCready, and Harris were nonetheless entitled to qualified immunity because there was a reasonable basis to believe that Nettles Nickerson was operating her Hummer while intoxicated and was therefore violating Michigan law. And then it kind of proves it. It's almost like a common sense test to the judge. He says, look, Michigan makes it a crime to operate a vehicle. Here, there's no dispute that she was intoxicated. Here, they make it a crime to operate a vehicle while intoxicated. There's no dispute that she was intoxicated, 0.165. Ding, ding, ding. You're intoxicated. Welcome to the world of intoxication, right? The only question is whether she was operating her Hummer. And so he goes through all of these facts that are like, well, you know, she opened the driver's side door, got into the driver's seat, started the car. I mean, it's very kind of, read this. Here, a reasonable officer could have concluded that Nettles Nickerson was in actual physical control of her Hummer. She had opened the driver's side door, comma, gotten into the driver's seat, comma, started the car, comma, turned the lights on, comma, then pressed the brake pedal, comma, and she sat behind the steering wheel while the vehicle was running. Moreover, no one else was in the car and nothing impeded her ability to move the car. What's the judge doing? The judge is trying to give you, Marshall, all of the facts here that are like, give me a break. She did this, she did this, she did this, she did this, she did this. But you could write it the other way, right? You could be like, she didn't do this, she didn't do this, she didn't do... Yeah, it's true that she opened her door and sat in her car, but she didn't do this and this, she didn't turn the key, or maybe she did turn the key. She didn't move it into drive, she didn't press the gas pedal, she didn't move the car, the car didn't actually physically move at all. She didn't do this, she didn't do this, she didn't do this, she didn't turn the headlights on, she didn't turn the radio on, she didn't, you know what I mean? So you would do all the things that would kind of suggest that it wasn't operating and prove it that way. And then what the judge does, starting on 291, is after the judge feels, what do I know what the judge feels? Thinks, I think he thinks. I've sufficiently kind of proven my case. Now I recognize that there's some counter-arguments, right? I recognize that, well, there is this case which says a person sleeping in a motionless car can't be held to be operating a vehicle, so I got to deal with that. So the court recognizes the counter-arguments. After the court has kind of sufficiently proven his or her point, right, the court feels like it has to address the counter-arguments that have popped up. Right, the citations from the party. I mean, if I say to you, hey, Jimmy Garoppolo, if I say Patrick Mahomes is a better quarterback than Jimmy Garoppolo because lower turnover, fewer turnovers, what if you come back and say, well, yeah, he has fewer turnovers, but Mahomes, when he fumbles, or how do I want to say this? Yes, he has fewer turnovers, but the turnovers that he has are more costly than the ones that Garoppolo has, right? Maybe Garoppolo has thrown 10 interceptions and Mahomes has only thrown 5. And I'm saying, well, that's one of the reasons why Mahomes is a better quarterback, because he throws fewer interceptions, right? He gives the ball over to the team less times. And your counter-argument is, well, wait a minute, that may be true, but the 5 times he turned it over were all pick sixes! And the team goes for 6 points, right? The other team scores a touchdown. Some of you are like, what? It's a touchdown, right, for the other team. Whereas Garoppolo just fumbles it because he's a weakling. He gets breathed on wrong, which I think this is factually true, by the way. And just drops the ball because he doesn't want to play, because he's got a running back that can just score all the points and run down the field, and a defense that will bail him out. So you might, as a court, have to respond to that counter-argument. Right? Acknowledge the counter-argument and then make an argument in response to that, address it. Does this make any sense? I mean, why do I emphasize this? Because this is just an opinion, but this same style of writing, we are going to step aside a little bit when we get to complaints, because that's a little bit more technical, and we're going to start talking about those as the class goes on. But this style of writing This, I'm gonna start by giving you just the quick and dirty, just the elevator speech, the quick bottom line up front, 30,000 foot view of the case, the topic that I need to email you, senior associate about, or junior partner about, the memo or reader. This is what's going on. Let me tell you factually what's happened, real facts, procedural facts, and let me give you the answer. Let me give you the answer and not hide the ball. And then let me tell you why my answer is the right answer. What's your answer? Prove it to me. And I'll give you the reasons why. And then prove that those reasons are right. And as counter arguments come up, as cases come up, deal with those cases as they address the counter arguments. Does that make sense? Okay. That kind of was longer than I thought, but that was what I wanted to kind of get out of the Nettles Dickerson one. What did you think about Belogan? Totally different. We're not going to go through it in as much detail because it would be kind of like beating a dead horse, but yeah. Tell me your name.
Hannah.
Hannah.
I thought the facts section was way too long for me.
Yeah, it's
and
very
I
long.
did not like the cites to the record because that would just like interrupted every single sentence, and I was having to like skip over that to try and finish reading it. And I thought, like compared to the other case, he tied his facts to what his arguments were, and so he
In this case?
in the Nettles Nickerson,
In the Nettles
he
Nickerson, yeah.
tied the facts section to what his arguments were to support it, and here there were some things that I'm like, you could have cut that out because like you didn't talk about it
Yeah.
in your analysis section.
Yeah.
But I did like that he did have the Roman numerals and the headings out of, because it matched, each
Yeah.
heading matched, like this is what I'm talking about.
Definitely, I want to echo the idea of you don't want to include facts in your facts section if they're not going to be. I mean, you want some facts to tell the story, right? Like Okemos, Michigan didn't come up. Do we need to know it was Okemos? Well, I mean, maybe you've been Okemos. So I mean, you want some facts to give you a flavor of what's going on, but you don't want too many superfluous facts. So that's true. So that's something that I think may have been a negative. A positive, though, I agree with you, is the headings help. I had you sit down and read the whole case, so you're kind of like, hey, I'm going to be bored. Like, buckle in. But if you're looking at this case for specific legal issues that may have come up in the case, like what happened with the jury, and maybe that was akin to what was going on in the criminal case you're now working on, or what about the suppression of evidence, or what about the sentencing issue, you could hopefully go to like 1C or 2E and zero in just on that issue. Because the reality with legal research is you're not generally reading cases from front to back, right? You're just getting in and getting out. Okay, I need this. I don't need to know what happened in, the FedEx Courier on Rutland Street, So I think that's a pop plus and a negative. Yes, somebody else had a comment. Anybody else? Yeah. Tell me to
Kirby.
Kirby. Okay.
I thought that even though this one was longer and had a bit more complicated facts, that Alfred did a good job of kind of like making it easy to follow along. I didn't
Yeah.
feel the need to have to keep going back and rereading. Like I understood it throughout, and
Yeah.
the other one, even though it was short, I found myself having to go back and be like, wait a second, because it jumbled the facts again. Was the end of this one, even though I got like bored towards the end, I
Yeah.
wasn't confused.
Why do you think the facts were so long?
I think there's a lot of layers to understand, and you can't just like explain what the person's charges were without explaining how it happened. Maybe you could, but
No, I think you're right
but
about-
it was useful because I would have been confused.
But tease that out a little bit. Like, you're right that there were a lot of layers to it.
Mhm.
Right, I agree with that. But what do you mean by that? Because that's right. What are the layers?
I guess because, and also he's challenging so many different things.
Yes!
And his challenges wouldn't make any sense if you didn't know why it went wrong for him. And
I think,
that first
honestly,
place.
I totally agree. There were a lot of legal issues at play. I mean, I think probably my guess is the judge kind of felt compelled to include those facts that were going to be relevant to the subsequent legal issues that the person was raising. I mean, this is kind of maybe I wouldn't call it necessarily a classic criminal case, but I mean, this is a federal criminal case that you would see, kind of a drug distribution case, maybe a conspiracy case. It's going to have a lot of legal issues, both with respect to the underlying crimes of conviction, but also the sentence. You're going to have issues with respect to both. And when an individual in federal court gets convicted of a crime, a lot of times they're going to want to throw a lot of issues on appeal. Courts of appeals may try to limit that to some extent, but they're going to be The courts are gonna entertain a lot of kind of discrete issues, and so you'll notice, right, the judge is now getting not just into the facts, but procedural facts, very kind of technical, toward the end of the voir dire, or what was going on. Well, you're thinking, why would they get into that? Well, they were only getting into that because later there's gonna be an issue about the voir dire, right? At trial, the government put on 8 witnesses. He puts on 3. All of the evidence presented. We're now into closing arguments. Why are they talking about that? Jury instruction, a pattern jury instruction. I mean, we certainly didn't talk about the jury instructions in Nettles Nickerson's underlying criminal case because it was totally irrelevant to the extent that the court even got to that layer of the proceeding, which I'm sure it didn't. But if you look then, you get to Roman, and then you get to sentencing. Pre-sentence reports, guidelines ranges. I mean, if you haven't taken federal criminal law or federal criminal sentencing, this all means nothing to you, but you're thinking real technical aspects of a criminal case. But on appeal, you'll notice the Logan challenges the voir dire, the admission of evidence, their closing argument, right? The jury instruction, the sufficiency of the evidence, the application of the sentence enhancement. So then it starts to become clear, okay, this is why we're getting in all of those issues. And maybe that could have been brought up at the beginning, kind of in the over 30,000 foot view. But I think the court just wanted to make it clear, like, hey, there was this underlying crime here, this person was convicted, and now they raise numerous challenges to both their sentence, to both their conviction and their sentence. But each of those claims lack merit. Because otherwise it would have been a lot of like, oh, well, he makes this argument and this argument. So this one, I think, and then we'll take a break because I know we're kind of past the halfway point. I think the point of this one is a little bit of a classic case, follows the same pattern. I think it does a better job of headings. And although it may not be easier to read front to back, I think they do a good job of thinking, it does a good job of expressing the idea that if you're doing research and you want to get in on just a piece of this, closing arguments or jury instructions, you kind of know where to go. The headings match the legal arguments that are put forward, and they're disposed of kind of in a succinct way. With, if you'll notice, for the most part, it's pretty much bottom line up front, prove it. Bottom line up front, prove it. Let's take a break. Let's say till maybe 8. Oh, is that right? Sometimes it's wrong.
Right.
7:57. Let's say 8:05. Does that sound good? 8:05, and of course we're going to go till 8:40. So we'll take a break till 8:05. No, you're fine. It's totally good. That was a good little signal to everybody.
I know that that's good in a lot of cases, a lot of situations, in some situations.
Honestly, I didn't mean to notice that. I like
Really?
when someone else said that. Like, looking back,
Yeah.
I'm so used to it.
Yeah, just a quick and blue.
Oh, citations.
Citation, skip that sentence. Yeah, I get that. And most of the time I'm able to do a lot of it, I just felt like this was oversized, I don't know.
Last week, I had trouble getting our Wi-Fi,
If you want to.
but
Shallow,
I was
man.
home and I couldn't.
Yeah, I mean, not a year about it.
Oh, take a look.
Yeah, for sure.
Do you
Yeah,
like
totally.
cereal?
I've done my
You do saying that you're being delicious and nutritious. Now I'm sure you can see that I'm being facetious and I truly enjoy your product.
Yeah.
All the different guys.
I saw this
I'd say that mine's definitely I feel like I'm very much
Last semester, at
Monday, Monday, huh? You know, that kind of guy, and the Wednesday hump day, and the Friday, the thing guy.
I'm okay with that.
Yeah, I don't know.
Yeah, so I can totally do
My
that.
Monday is just, alright, just the Friday's hard. I don't do that.
No, I will say I think I have caught myself saying that Dragon Tuesday, they go, well, you know what they say, it's the most productive day of the week, huh? And just walk away, and be like, wow, you're so interested until you shut up next time.
Yeah, I'd be happy to talk to your friend.
really
multiple,
cool.
and all that kind of stuff.
It's like a lot.
It's a combination. I can do it on my own.
Hey, how you doing? Good.
Yeah, just one would set it up, and then I've done
The
like
most interesting
solar
one
panels with,
was they actually,
like inverted
somebody
to either center of
recommending
the government
a
and
play or a movie or something to another person and they went and saw it.
You know,
Other than that,
view
it
of
was
it.
hey, how was your weekend? Good, didn't do much. Well, talk to you later. Can we all just establish that we had a good weekend and just move on? None of us really want to talk to each other anyway, we're all tired.
I'll listen to you.
Yeah, for sure.
Not only
Yeah,
does it
that
have
can
the
give
wall,
perspective.
it also says this has another room. Bunch of big blue.
Now, probably they're in town, they're out of town, the government has to consider it.
This thing
Yeah,
is really.
totally. Just think about it, set it up.
Something
Look, how about
just
me?
about it.
And I'll just.
And the other girl completely shut it off.
No, no, what was it good to see?
Just like started going into this really long story. The first lady was like trying to be nice about it and like asking her questions.
Or no, not on Monday.
She's like, wow, this is
Ooh, they cut off my story, huh? Yeah.
You don't have to, you don't feel much like you're coming in.
All jokes
just like.
You didn't peek at I think you're gonna be fine. You're in the law school. I think you're gonna be okay.
There's like nothing else.
Yeah.
Oh yeah, I'm stuck on one
I think we all have that.
Or I could give you more like.
It's not a fair
Yeah.
Softball specifically?
Softball.
Wow. I would not have picked that. I would not have guessed that. They're way too much about their kids. Mine is it's not even specifically sports. It's the parents that the reason their kid plays that sport is because mom and dad said you're gonna play this sport because I played that sport. So I'm living like I had several friends who they live vicariously through their children. Or several of my friends, their parents live vicariously through them. Wherever I see them, especially now when I'm out, I'll be like, oh hey, even though they're not playing sports anymore, and I'm like, oh hey, how are you? And they're like, great, Jim's doing this now and that. And I'm like, I know, he's a friend. I talk to him too. And I don't want to talk about the accomplishments of your children. But yeah.
Love to tell me that about their children, so they just automatically ask. When's it?
Please tell me how rich he is now.
Yeah, probably.
I couldn't imagine if I should.
So we just send them a message to different households and hey, fix this and send it back because
Every
she
time
might
I'm
be
like,
almost 20 now. And the first person did not pay attention to the fact that she was almost 19 when we filed. Has been 19 for over a year. Almost over a year. Like, oh. What are you trying for you? You send this to her dad. Stop over your dad too.
this thing right now, the online classes are stupid.
to that. And if you take labor law and stuff, you take that sports law class, I looked at it as a CE based and stuff and all, and so like, it's a good segue.
All right, guys, I think everybody's back for the most part, so let's get started. Okay, let's turn our attention away from, just general concepts of good legal writing to now really kind of the substantive part where you're thinking about the content that we're going to glean from some of the reading materials. Hopefully is stuff that you'll start actually kind of in a more concrete way incorporating into some of the documents that you start to generate. So, going back to this, I think I kind of put this on maybe on the first day of class where we talked a little bit about just an introduction, which I think includes concepts of good legal writing. And we're now in this kind of first category of documents, which are those documents that fall under the broad category of civil litigation. Today, what we're going to talk about is just this little part, which is a general introduction to litigation-related documents. We're going to just review this reading material, and then once we do that, you'll kind of leave class today thinking, all right, I'm going to start to learn in a very kind of specific way about substantive complaints, and this is what the reading is for next class. But what you'll see is the documents we're going to be talking about are indeed civil complaints, answers, and then we're going to immediately move to motions, which include both motions to dismiss, motions for summary judgment, and non-dispositive motions. We will focus, you will certainly be drafting complaints, answers, and at least one motion, most likely a relatively short motion to dismiss. But we'll talk about kind of what those look like as we get there. We'll also touch on discovery-related documents, but really, I kind of think it would be best if you focused on those documents that both initiate the pleading and then function also as defensive pleadings, like an answer or a motion to dismiss. So although we'll talk about it, they're not going to be kind of the focus of our discussion. So that's where we are. But what are we talking about today? Today we're going to focus really just on general introduction to litigation-related documents and introduce you to the idea of complaints. So let's look at this reading material. We're going to kind of follow it pretty closely. Complaints really are these pleadings requesting affirmative relief. So this subsection on affirmative relief is there, and basically what you see is that we're thinking about lawsuits here. We're not talking about criminal litigation, which would be initiated whether, by a state or a federal, maybe grand jury indicts someone, and then that's the docket entry 1. I'm thinking about federal court, what I do every day. On the criminal side, docket entry 1 is usually an indictment, and that's what initiates a federal criminal case in most instances, not all. In civil litigation, right, lawsuits, those are cases where an individual is basically they've suffered some sort of harm and they're seeking some sort of relief from the court, right? They want the court to provide them with affirmative relief. And there are different forms of relief. What are the forms of relief that an individual may seek in a lawsuit in state or federal court? What do you think? Different types of relief a plaintiff would seek. Yeah.
Monetary.
Yeah, monetary relief. Yeah, money damages, right? That's the most common form of relief. But what else? Yeah.
An injunction?
Yeah, injunction. Injunction, what is an injunction?
Getting someone either do something or stop doing something.
Yeah, do this. You are ordered to give me medicine, or you are ordered to tear down that barn. I had a case like that, but there was like, your barn is on my property, tear it down. And the person was like, no, my pigs are in there. Well, you shouldn't have put your pigs in a barn on my property. And it was on the wrong property. But yeah, injunctive relief, a court ordering you to do something or not to do something. There's also a declaratory judgment. That's a third form of relief. Not as common, but you're asking the court to declare something. One, I guess, example that I've been thinking about recently might be something like, it might be like an executive privilege type situation. You're kind of thinking about this in the news today with like, impeachment proceedings and people, oh, is this person going to testify or are they not going to testify? There's a lot of layers to that are beyond me, and who knows what the answers are. But I suspect if somebody was saying like, hey, I'm willing to testify, but this person doesn't want me to testify, there's an executive privilege claim, you might go to court and get the court to kind of declare what the answer is. and then you would testify or not testify. Nobody's seeking money damages. It doesn't really seem to fit in the world of injunctive relief, but I think that could be an example of declaratory judgment, just an example. But anyway, what you're thinking now is, okay, I'm in the world of civil litigation, I'm thinking about documents, and I'm thinking, okay, in this world, complaints are the pleadings that a person files, a plaintiff files, when they're seeking some sort of affirmative relief. They're typically saying, I was harmed, here's what happened, and here's the relief that I'm seeking. And so specifically, the types of pleadings that are out there, there's different types in theory, right? Some jurisdictions use the word petition, right? I mean, I'm so engrossed in federal court that when I think of a petition, I think of a habeas petition, right? And if somebody's seeking habeas relief, they're oftentimes trying to get out of custody, right? I mean, I'm in federal custody for this reason or that reason, but I want to seek relief. I'm filing a petition for a writ of habeas corpus, and I want the court to declare that I shouldn't be in custody anymore. Petitions are not language that we use in this context. We focus on the initial pleading, that is the complaint. And so in the complaint, basically it serves a couple of purposes, right? It gives notice of the plaintiff's claim and the grounds on which the claims rest, right? It says the principles for drafting an initial pleading are set out in chapter 2, but the point of the complaint is basically to say, like, look, these are the factual allegations that I'm asserting. Here is the form of relief. Here's how I was harmed. Here's the relief that I'm seeking. And I'm going to give you, the defendant, notice that you're being sued. We're going to talk in very specific detail about what you need to put in a complaint, but that's for next time. We're just kind of introducing you to the idea that, hey, litigation starts with the filing of a complaint. Page 7 of this reading assignment, the second PDF page, talks about the different types of claims, right? You can have a plaintiff filing a lawsuit against a defendant, and that is the initial pleading, right? The complaint. Some jurisdictions refer it as the petition, but that's the claim, right? The counterclaim is the claim going in the other direction, where a defendant responds by filing not just an answer, but maybe files his or her own lawsuit, pursuing their own claim for damages. You could also have a cross-claim, which would be something like this. Plaintiff is suing defendant 1 and defendant 2. So you've got claims going from the plaintiff against both of these defendants. A cross-claim would be if the defendant, one defendant sues another co-defendant. A third-party defendant, I mean, this is like PTSD from civil procedure, which I love. You probably don't. Do you all have all those like little rule joinder questions? Was there one of those on the exam? You're like, what's it gonna be? Third-party debate. I know, yeah, I didn't like it either. Now I love it. I also read some rules of civil procedure for fun, so I mean, this is who you're talking to. This would be a third-party claim, where the plaintiff is suing the defendant and the defendant brings in a third-party defendant. That would be a third-party claim that's referred to in the material. We're really just going to focus, I mean, this is not a joinder, advanced civil procedure joinder class. I mean, nobody would have been right? We're going to focus on plaintiffs suing defendants and asserting one or more claims, right? That's what we're going to focus on. So when you draft a complaint, that's what you're focused on. Before we get into defensive pleadings, which is the answer, because we're going to really be spending the next, I would say, 2 weeks focused just on complaints, I do think it's worth kind of thinking about what goes in a complaint, just almost like a 30,000-foot view of it. A complaint is not an overview of your case. Totally. It's not a, here's what happened, and here's why my claim is viable. Really what it is a list, a numbered list of factual allegations that, believe it or not, are written in a really neutral way. That's all it is. It's just a list of factual allegations that are written in a neutral way. And you're alleging what are called ultimate facts. And the idea is that you've got a numbered list of factual allegations, also known as ultimate facts, where you say what happened to you in this case. And if those allegations are true, they would necessarily prove up whatever legal claim you're asserting. This is like a lot of words, right? What does any of that mean? Let's go back to like the whole duty breach causation damages example, right? Like we all know torts, and we know what a prima facie case of negligence is. But when you're filing a complaint, you'll see a lot of different things, but I think what you really want to think about when you're drafting a complaint is you're not using the words prima facie or duty or breach or causation or damages in your complaint. Now, I say that a little bit loosely in the sense that I think there can be a role for those words. We'll see this when we get to complaints. As far as headings go, or for the limited purpose of kind of orienting the reader. But really, a complaint is you're saying factually what happened to you. And if those things are true, then all of the elements of a negligence case are met. So, if you're trying to say, hey, you know, this is not what you would say in a complaint, but if I'm an attorney who practices negligence cases, right? I'm a plaintiff's attorney who handles tort cases, and you're just somebody who went to Kroger and you slipped and fell on a banana peel in the grocery store, and you hurt your back, and you want to file a slip and fall negligence lawsuit against Kroger, and you come in and you say, hey, you know, I was at the Kroger on, I don't know, 3rd Street. And I slipped and fell on a banana peel in aisle 4, and I didn't even see it, and I fell and my back is now severely injured, and the spine is all destroyed. Big banana peel. And this is what happened, and here's my medical records, and this and that. If I'm drafting a complaint, I'm going to start out by saying something like, on this date, Hannah, is that right? Kaylee, so totally wrong. Who's Hannah? Who's Hannah? Hannah, I don't even know my client's name. Dismissed! You're an idiot. It's after 8 o'clock, okay. Kaylee, on such and such date, Kaylee went to the Kroger on 3rd Street, period. Okay. Kaylee was walking down aisle 4, period. Number 3, Kaylee slipped on a banana peel that was laying in the middle of the floor, period. Number 4, Kaylee injured her back, period. Number 5, I mean, this is a little absurd, but very just neutrally, not like negligently, Kroger negligently left a banana peel. No, you're in a very neutral way, and you'll see this. We're going to have a reading. That's what the next reading assignment is about, is how you draft these things. But ultimately, it's just a very kind of neutrally written series of factual allegations, where it's almost like one allegation per number. And the thought is that if you've laid out this narrative in a thoughtful way as a plaintiff's attorney and a plaintiff, you've got the allegations, and maybe to the side in my office, I have a list of the elements of the cause of action for negligence, right? I know behind the scenes, I got to prove up the existence of a duty, right? Hence, I have to kind of establish that there was a employer-customer relationship, and I must know under the law that that gives rise to a duty of care, kind of like the landowner, licensee, invitee whole thing. But I've got in my office somewhere all the elements of the cause of action, but I'm not drawing those into the complaint. I'm just writing my allegations in a neutral way that if all of those are true, hey, there was a duty here. Hey, looks like Kroger breached that duty. Hey, that breach, that leaving the banana peel, let's just leave garbage in the middle of the aisles so people can surreptitiously slip, or water is just laying in the middle of the aisle. That would be a breach of the standard of care. You owe your customers a duty of care to keep the aisles, I'm making this up, maybe it's not true, maybe you don't, but you owe your customers the duty of care, and that duty is to leave your aisles in a condition that people can safely walk through. You breached that duty of care, and that caused my client harm. But it's not written in a way that's making the legal argument. You're asserting ultimate facts that, if true, prove up all of those elements. Why do you write it in that way? You write it in that way because, and then at the end you would say, and she suffered injury, she has scoliosis now. I don't know. You don't get scoliosis. It's really like, you know what I mean. You have a severe spinal injury, and therefore you have X amount of dollars in the totally stupid. Okay, that's one I'll want back. You write it in a neutral way, though. Why? Because you've got to think about the answer. You've got to think about what's coming back in litigation. If you write your complaint in a very kind of neutral way where you've got bulleted factual assertions, what you get in response is, in most cases, an answer, a substantive answer. And what's an answer? We're going to learn all about those too. But what the answer is basically another number list. And each of these numbers in the answer correspond to each of these numbers in the complaint. And they admit the allegations in this numbered paragraph, they deny the allegations in this numbered paragraph, or they may try to do something in between, which is like, I lack sufficient knowledge to respond to this. So, if you say, on such and such day, Kaylee went to the Kroger on 3rd Street, what you want to come back is, what you as a plaintiff want to get from the defendant is them admitting that allegation, right? So we can narrow the issues in the scope of litigation, right? Did you slip on a banana peel? Did they admit that? Did they deny that? Maybe they admit that. Maybe they admit it, and maybe they think, you know what, you don't get scoliosis from a slip and fall, you idiot. Maybe that's their case. I mean, it's laughable, but that's not crazy. Maybe it's you've pled damages that were pre-existing, right? So yeah, you went to Kroger. Yeah, you slipped on a banana peel. Yeah, you suffered an injury, and maybe you did sustain damages that were caused by our negligence, but the damage, it's all a fight about damages, right? The point is, you want to write your complaint in a neutral way that lays out the factual allegations so that you as a plaintiff can get information from the defendant. They're admitting these allegations, they're denying them, or they're stating that they don't have sufficient knowledge. Why is that a better way to write it than littering your complaint with terms like negligent, cause, breached? Why don't you allege those things? What do you guys think? Why write it neutrally? Why not be like, this is our chance to tell the court what happened, let's go with it. Yeah.
I think, because like you said, the whole point of the complaint and the answer at the beginning is to narrow down what you're looking for. I mean, obviously the plaintiff is arguing that defendant did something wrong and likely that they did something negligently. But if you put that in your complaint, defendant will come back and say, deny.
Yes. See, if you say they negligently did something, that's a loaded term. What does that mean, right? I can just safely deny that, right? And there's an ethical kind of duty. This isn't a legal ethics class, although I love ethics. I teach that every summer. Come take a visiting class at UK PR this summer. But there's an ethical obligation to be truthful in your pleadings. And so you can't just deny that the plaintiff was at your store on January 3rd if you have a factual basis for believing that, right? But if you write, and you similarly, if you have a factual basis for believing that they slipped on a banana peel, and you know that, you have to admit that too. But you don't have to admit that it was there because of your negligence, right? That's a whole legal argument. So you're 100% right that if you write it in a non-neutral way, you're going to start to get denials, right? We're going to talk about all of this, but it's important for you to think at this point, we're in the world of litigation, civil litigation. The initial pleading is a complaint, and you want to move away from kind of thinking about writing in a way that includes legal analysis. What makes complaints, answers, and to some extent motions to dismiss a little bit different than the rest of the classes, they're more technical. There is kind of a format. And the big picture format is, a list of facts. A list of factual allegations that are neutrally written that, if true, would prove up your cause of action. And that are written in a way that is neutral enough where you can glean as much information as possible from the defendant to get your, to kind of narrow the issues and hopefully prove up your claim. The defensive pleadings, of course, though, are the big one is the answer, right? It responds to the allegations in a pleading that requests affirmative relief, and it sets affirmative defenses, which we're going to talk about. You're not only going to admit or deny each of those allegations, you might have an affirmative defense at the end of it. What's an affirmative defense? Affirmative defense? Anybody?
No.
Go for it. What's it? I mean, I just said scoliosis comes from a slip and fall. So I mean, it's a safe world. Well, yeah, I think the defendant would bear the burden of proving an affirmative defense. Good. What are they trying to prove? Very good.
But
Yeah.
Isn't it something about like it would be impossible?
Well, impossibility might be one, but what?
It's like, I might have been responsible, but I have a reason why I'm not liable.
It's kind of like, yeah, it's like, hey, even if everything you're saying is true, it doesn't matter. And here's why. A classic one would be like statute of limitations, right? Hey, I came to you, this doctor, for my horrific, surgery and you removed the wrong limb. Right, I had a wound, and you were supposed to care for this wound and do surgery on this leg, and instead I woke up and this leg is missing. That's horrific, right? And that's also medical malpractice. I mean, that's like, that is malpractice, okay? But, there may be a statute of limitations, and you waited 5 years. So even if it's true, even if this is true, and this is true, and this is true, and this is true, an affirmative defense may be statute of limitations, right? So even if you've got the best med-mal case, it's like the cleanest one to prove, that would clearly be negligent. You may be barred because of the affirmative defense of statute of limitations. Or, yeah.
Assumption of the risk.
Assumption of the risk is a good example of an affirmative defense. You assumed the risk that was involved here. Contributory negligence, right? Remember learning about those? Now, a lot of times first-year tort students often learn about the difference between comparative fault and contributory negligence. Which state are you in? If you, as the plaintiff, I was at Kroger and I just decided to take a stroll down the poorly lit aisle that had a tape in front of it that said, "Do not enter." But I thought, you know what, this seems like a good place for the organic foods. I'll go in here, right? And I slipped and fell. Oh my God, why was there water there? Well, maybe there was some negligence there. Maybe the tape wasn't clearly labeled, or maybe you could make out a negligence case. But maybe in defense, not only is the defendant contesting some of the factual allegations that you've put forth with respect to the substantive legal claim of negligence, but they're also arguing kind of comparative fault or contributory negligence. You too were negligent by going in a cordoned off area that was poorly lit and kind of suggested that we don't want customers to go in this section of the store. Then you've got to ask yourself questions like, well, what sort of jurisdiction am I in? If I'm 5% at fault as a plaintiff, does that completely bar my recovery? Does it reduce my damages that are available? We're not going to, this isn't, again, an affirmative defense class. But this is to make you aware of the fact that the plaintiff is going to allege factual allegations that, if proven, if true, are going to go to each of the elements of the cause of action. The defendant is going to admit or deny those factual allegations, and then in a separate section of the answer is going to put forth any affirmative defenses that he or she may have. So that's another purpose of the defensive pleading, and of course the actual kind of technical parts we'll talk to when we get there. So moving along, some of the other requirements regarding pleadings, motions, and other papers, you've got to have a caption, right? I mean, that's the first thing there, right? I don't want you to think that this class is going to be won or lost, right? I mean, your performance in the class is not like, how good's your caption, right? You might have signed up for this class and thought, legal drafting. It's going to be super technical, and he's going to be looking at the caption. He's going to be reading my signature block. No. Does that mean you don't need it? No, you totally do. This class could be taught in the technical way of make sure your captions all look perfect. And you need a caption. What do you need? You need the name of the court, you need the title, you need the file number, you need the designation number. It should look like what's at the bottom here, this basic caption format. I mean, you are on duty for that too. But, you know, like, I want to write. Let's talk about writing. So you're kind of just all, like, required to follow the standard rules for what you would need in a caption, right? The content of a caption, the basic caption format. But don't think that what my big takeaway from this class is like, oh, you only had, like, 4 parentheses there as opposed to 5. Like, you know, there's a little bit of leeway. You would want to follow whatever local rules are in your jurisdiction for captioning. With respect to captions and the like, any kind of procedural, technical kind of rules like that, those will be included in some of the case files, so I think you'll kind of have a sense of what to do. Local rules often address captioning. Other format requirements, I mean, there's really not much to say here. In the federal courts, you're going to follow the federal rules of civil procedure. State courts, there's going to be state rules. I mean, this class, you're going to, as a practitioner, you're going to look up the rules that govern the filing of documents. Is it filed in the state court? Is it filed at the courthouse? Do you do electronic filing? Those are all things that are going to be governed by your rules of civil procedure or your local rules. One thing to note here is about the incorporation of exhibits into pleadings or motions. In federal court, if you attach an exhibit to your pleading, that's considered a part of the pleading. In state courts, some of the rules differ, but I think they generally kind of follow that same advice. Verification of pleadings, you've got to file, you've got to sign your pleadings. And then we talked a little bit about electronic filing. Those generally exist. That's the CMECF system in federal court. And I think state courts are now starting to get more and more on board with the idea of electronic filing. Service, that's the example of a summons, right? You're not going to be drafting summons, a summons. Those are in part because those are documents that are issued by the clerk of the court. The idea, right, is if you file your complaint, let's say in federal court, what the court will then give you as a litigant, as an attorney representing a litigant, you would also file a summons with the court, and then they would give it back to you. They would sign it, make sure everything's in order. They would give it back to you, and then you as a private party would have it served on the defendant, so that they would have notice and they could file a responsive pleading. It's a little different in some of the cases that I handle involving prisoners, because prisoners have people from federal prison. So if they proceed as a pauper, then we have the marshal serve the defendants with a copy of the complaint and the summons. But that's very technical. We don't have to worry about that. The last thing I just wanted to kind of briefly touch on is this idea of Rule 11. What does Rule 11 provide? You all know? Yeah.
It's what you're saying in your complaint. It's not a frivolous complaint. What you're saying is true. You've checked out the facts and you've made sure the law is applying to the facts. And if you don't have the right facts, you will uncover those facts that you're alleging.
Yeah, exactly. I mean, I think this kind of is, it's not something that we focus on too much, but it's kind of behind the scenes when we're drafting our complaints and answers, because you want to be truthful in your submissions, both with respect to the factual allegations that you're laying out and what sort of statements you can make in response. The effect of presenting a document to the court is that you're basically certifying it. You're certifying to the court to the best of your knowledge that all of the following is true. You're not presenting a signed document for an improper purpose, that it's not frivolous, right? That you're going to support the evidence, that you're going to support your factual contentions with evidence and the like, everything that Hannah pointed out. There can be sanctions that are imposed, and then Rule 11 also specifies that it has to be signed, and it's had some impact on the state courts. Basically, what I want you to take away now, there's no drafting exercise for the next class. I want you to read the reading assignment that's on Twen. Let's go back to Twen real quick. 2 minutes. So go back to Twen. The syllabus has been updated. There's no drafting exercise for next Saturday, so you're off duty with that. And I want you to go to this reading assignment for February 3rd, which is next Monday, and it's on this initial pleading. This is the reading assignment, the substantive reading assignment that goes into detail about complaints. And we're going to spend quite a bit of time breaking this down and talking about what exactly we need. Because from here on out, we're going to have pretty regular weekly assignments drafting these documents. And I do think that this Temple, Smith, and Couples piece on complaints is good, because it really kind of lays out in detail, not just what the purpose is, and the different requirements that exist in both state and federal court, but also just this kind of procedural stuff, like what exactly you need in your complaint in order to, glean as much information as you can from the defendant, but also avoid what is another possibility, which is the defendant responds to your complaint by filing a motion to dismiss. See, if you don't include enough factual allegations in your complaint that go to each of the elements of the cause of action for negligence, let's say you just leave off the damages allegation, or leave off anything about causation, right? The defendant's gonna come back with not an answer, but a motion to dismiss your complaint for failure to state a claim. So it is important how you draft these documents, and you really wanna think, I would start kind of really focusing in on this subsection 4, the format, and then this is where it gets really good. 4 types of allegations: an allegation, a legal conclusion, ultimate facts, evidentiary facts, all of this stuff. Because really, what you want to focus on is this use of ultimate facts. It's a good discussion. I think it kind of, in a technical way, kind of reveals to you, hey, this is what I'm really trying to accomplish in my complaint. And I think for a lot of students, it's a little bit of a mind blower, because you think, like, I want to prove to the court that I'm right. No, that's not what the purpose of a complaint is. This isn't like a memo to your boss about whether you think, Kaylee's got a, is it Kaylee? Mm-hmm. Yeah, that Kaylee's got a viable claim. Like, that's a different thing. Like, that we'll talk about. This is like, are you properly pleading your cause of action in court? So, just read it closely, and be ready to kind of talk about it and dissect it before next class. And then there's a lot going on, right? The Super Bowl, so we'll talk about. My money's on the Chiefs. Now watch it. It grew up a little, throw for like 500 yards, and then I will be in Vegas. That I just want to talk about. All right, have a good week. I will see you next week. And don't forget, if you don't mind, please bring an extra hard copy of your drafting exercise by the Nettles Nicholson case and the Belogan case. Just out now. See you guys later.
500. No, if you don't agree, 250 to 300. I will be. I'll eat my shield for that.
Oh, nice. Okay, there you go. Hey. I'm actually, you know what, to be honest with you, I'm not. I mean, I'm definitely not a cheese fan. I'm not a 9
I've had friends with like for those.
Oh, yeah. Well, I'm bitter.